The topic for tonight is whether Harvard should admit Gina Grant. Although that's the formal topic title, I think the real question is whether Harvard should have rescinded Gina Grant's offer of admission in the first place. This is an event at Harvard that has gathered national attention in the media. The New York Times wrote a lead editorial not in favor of Harvard's decision and stating that Harvard should not have rescinded their offer of admission to Gina Grant. It has received national press attention throughout the country, and in my mind, the reason for that is partially because of sympathies for and against Gina, but also because this debate raises many interesting questions about the way that we treat juvenile criminals or people who have pled guilty to juvenile crimes in America after they've served their official times. And it raises more questions about social responsibility and child criminals in general. And that is the reason for tonight's debate. This is something about which the Harvard campus is surprisingly split. Usually Harvard is thought of and tends to be a pretty liberal university, but in a poll conducted by the Harvard Independent last week of about 1,500 Harvard students, 54% of the students here responded yes to the question, do you think that Harvard should have rescinded Gina Grant's admission, whereas 46% responded no. This is something which has created many sort of unholy alliances on this campus with liberals and conservatives split. And for that reason as well, it's interesting because it's not often that an issue divides the Harvard campus so closely or along such strange lines. With that introduction, I have one more explanation. As most of you have probably noticed, Josh Liston is not with us tonight, and he has been replaced by Derek Ho. Josh was invited to be on this panel because he had been one of the leaders in the movement to stop Harvard from rescinding Gina Grant's admission or to admit her once again. He organized a protest which received national media attention in front of Barley Hall last week, and he's been very outspoken on this subject. However, Josh, through a third party, was told that Gina did not want any more attention focused on her case. And he stated that it has always been his aim to advance her cause as she defines it, and that he did not feel comfortable participating on tonight's panel knowing that that was against her wishes. So he has been replaced with Derek, who will also be a wonderful panelist and has been also very active in the drive to have Gina admitted. He's been quoted numerous times in the Crimson, and he's a very active political figure on campus. With that, I would like to formally introduce the panelists. To my far right is Derek Ho. He is currently the president of the College Democrats and the managing editor of Perspective, Harvard's liberal monthly. To my direct right is Scott Schuchart, who is a senior editor at Perspective. To my left is Steve Frank, the former editorial chair of the Harvard Crimson, and to his left is Dave Latt, an associate editorial chair at the Crimson. This order of events at tonight's panel will be that each of the panelists will deliver a 3-minute statement sort of outlining their position on the case of Gina Grant. Then we will have some time for debate and questioning among the panelists, and then we will open it up to questions from you. Our first speaker tonight will be Derek Ho.
Thank you. I sort of feel like the backup quarterback on the Go Gina Grant team, but I hope those of you who came specifically to see him will be satisfied with me as a replacement. I'd first, I think, like to set out exactly the way in which I've interpreted the question for tonight's debate, because I think the word should in the question is slightly ambiguous. And I'd like to talk about the question not on a legal level, because I think everyone here would sort of agree that Harvard has the legal right to do a wide variety of things, and I don't think the question of their legal right would be a productive one right now. And I think the question of Harvard's legal right will be resolved if and when the case is litigated. I think the real question here is a slightly more abstract one, that is whether Harvard's revocation was just. And I think this question does not allow Harvard to sort of stand on its rights, as Aristotle would say, but really revolves around the deeper question of the justice of this decision. And to address that, I think the first question that has to be posed is a question about the juvenile justice system. Juvenile cases are sealed because the system views offenders as children, and as such, their crimes are not really indications of sort of inexorable moral depravity, but rather of sort of temporarily misguided behavior that can be corrected as they mature. And so based on that system, we desire and facilitate their juvenile offenders' reintegration into mainstream society. And of course this is important because this was exactly the case of Gina Grant. The legal system in this case ruled that her case ought to be sealed, and although she never really had a chance to plead her case, and just sort of to correct Michelle, she pled no contest to voluntary manslaughter, which is different from a ruling of guilty for voluntary manslaughter. Despite the case that the fact that she never really got a chance to plead her case, the judge in the case, the Honorable Mark Westbrook, decided to punish her for 6 months, to seal her case, and to promise her a new start here in Massachusetts. So I think the first question in this case must be, do we view this philosophy behind the juvenile justice system as right, as just? And I personally believe that it is. I personally believe that we ought to give juveniles the chance for a new start. And I think a lot of people, those who are for and those who are against Gina Grant, view this system as just as well. The question which follows, I think, is whether Gina Grant therefore had an obligation to tell Harvard, whether through the interview or through the application, about the matters which were sealed. And I think we have to look at this, obviously, in light of the fact of the judge's decision, which basically was a promise that no employer or that the court would not indicate to employers or to university administrators or to any other people who were in a position to judge her that the court would keep the sealed records confidential. And the court specifically ruled that Gina Grant should not be judged on the fact that she killed her mother, which in legal terms would be prejudicial to the entire rest of her moral character. Well, I think if we view the non-disclosure laws as just, then we have to conclude that Gina Grant had no obligation to tell Harvard what was in those sealed files. And I think the question of misrepresentation is sort of a fuzzy one. First of all, it's unclear as to whether in fact she did misrepresent or simply omit facts from her application or statements in her interview. There are conflicting reports, and I don't think anyone here really knows what the truth of that matter is. But secondly, I think misrepresentation should not necessarily be punishable by Harvard in light of the fact that the non-disclosure laws existed and that the case was sealed. If you can imagine, let's say the question on the application had been a lot more pointed than the question on the application was. Let's say the question had been, have you ever killed your mother? I think it is fairly clear that a misrepresentation in that case is instrumental to and necessary for any real and significant interpretation of the non-disclosure laws. And I think that in this case, the misrepresentation was not necessarily malicious. It was not necessarily an attempt simply to deny, to misrepresent in the sense that we view misrepresentation as immoral. Rather, it was an attempt to secure for herself the promises that the legal justice system had given her, which is a new start. And I think, in essence, that the misrepresentations, if they in fact existed, were not morally blameworthy, but rather an attempt to provide for her the rights and protections under which she stood based on the laws of the state of South Carolina. Finally, I think it is clear that there are particular circumstances regarding both the killing of her mother and the misrepresentation, and I think ultimately those particular circumstances ought to have been taken into consideration by Harvard. Are lies and misrepresentations the predominant moral trait possessed by Gina Grant? I think that is the fundamental question that Harvard ought to have answered, and I think Harvard did not go out of its way significantly or at all to answer that question. And I believe that based on reports, based on newspaper articles, it is clear that this misrepresentation was not the predominant trait in her character, and that at the very least, Harvard ought to have figured out whether it was the predominant trait in her moral character before summarily rescinding their admission to her.
Okay, our next panelist will be Dave Latt.
Okay, before I look at the particulars of the case before us, I just want to make a few brief prefatory remarks. The first one I want to say, and perhaps some of you who are familiar with my writing will know this, is that I'm not speaking as a representative of the Crimson tonight, although I do hold a position on that organization's executive board. If you want the Crimson's official position on this issue, I would refer you to the April 12th staff ed on Gina Grant, which supported Harvard in its decision to rescind her application. And I think that both sides in this debate do have a lot of valid points. And my remarks this evening are just based on my take on the case from what we know currently, and the facts of the circumstances surrounding the rescinding of Gina Grant's admission. I think before going on to look at the case, I just want to focus on, as Derek did in a way, on what this case or what this debate is not about. And I don't think it's about necessarily whether or not Harvard could have handled the matter better. I mean, I would freely admit that Harvard could have handled this matter better. This is a point that the New York Times addressed in its staff editorial. Sure, Harvard could have handled this matter much better. But the question is, and the question is not also, as Derek pointed out, does Harvard have the right to rescind acceptances? Because clearly it does. The question I believe that we have at hand tonight is whether Harvard was justified in this particular instance in exercising this right to rescind. And I think it was very justified. And I just have essentially, Steve and I have, I guess, allocated the various points on our side, amongst ourselves. And the point that I'm going to focus on tonight, the focus I'm going to focus on in my remarks, is that it was justified to deny Gina Grant admission because she misrepresented herself in the application process. Now, right now, as Derek alluded to, we're not perfectly clear on the circumstances surrounding her admission. But it appears right now that there was a dual act of misrepresentation here. That first of all, there was an act of omission where she did not allude to this incredibly significant event in her life, and also in her mother's life, in her admissions materials. And the second thing that she did, according to the Crimson as reported on April 13th, was that she lied to an alumni interviewer when asked about the circumstances of her mother's death, saying that this death, which she herself caused, was the result of a car accident. So clearly, there have been some major misrepresentations and some definite, I would say, mistruths that were propagated by Ms. Grant as she filed her application, as she sought admission from Harvard. So the question then becomes, why is Harvard justified in rescinding this admission? Derek raises this point, well, these misrepresentations, were they really that significant? And I think that what she withheld from the admissions committee was very important. First of all, it was something of major importance in her life, of unparalleled importance. This wasn't just a minor omission, she was guilty of shoplifting and she didn't mention that to the committee. This was something very major for which she served a significant amount of time in the juvenile detention system. The second thing about it is that it raises very serious questions about her moral character, which Steve will talk about. And thirdly, and another interesting thing about this omission of hers, is that what she did and what she concealed, what she did affected, or rather, you could say, brought about her status as an orphan, which, as the Crimson reported, made Ms. Grant stand out among a variety of many other applicants who had similar credentials, or even better credentials than she did. And so this was directly relevant to the consideration of her particular case, to her status as an applicant to Harvard. Now, given this dishonesty, this failure to bring forth the full truth, in a process where accurate self-representation is of crucial importance, I think it was entirely justified that Harvard rescinded her admission. Joe Rinn, the spokesman for Harvard, as quoted in the New York Times, stated that Harvard from time to time withdraws admission offers if a student engages in behavior that brings into question honesty, maturity, or moral character. And I think that her omission of this tremendously significant event, whether or not she was legally obligated to do it, clearly brings into question her honesty as a person. Now, let me just, before closing my remarks, I just want to look at the argument against her telling the truth and why it is flawed. Now, essentially, the argument runs along, as I understand it, runs something like this. Well, Gina was well within her legal rights when she checked no in response to a question about disciplinary problems, since the records of the juvenile court, as Derek talked about, were sealed. And I think that we can safely on this side concede that she was well within her legal right, or that she was not legally obligated to tell Harvard about this. But given this, I have about 3 questions. The first one I would like to ask is whether this legal obligation required her to tell a mistruth when directly asked about this case when interviewed by her alumni interviewer. The second thing I would ask is whether legal obligations are perfectly coextensive with what Harvard, as a private institution, has the right to expect from its applicants and, in a certain sense, its future students. But we have to recognize that simply because she wasn't legally obligated to disclose this does not mean that Harvard cannot take her to task if they deem that she did not meet requirements which they themselves have set for honesty and moral character. For example, if we take this argument, it leads us to two very false conclusions. One, that anyone who stays abreast of the law has the character which Harvard is looking for. And two, Harvard cannot pursue administrative board proceedings, for example, because, hey, it cannot go above and beyond legal standards for behavior when it is looking at its students or applicants who are future students. Clearly, this is false. And the third question that I would like to look at is whether or not the fact that this information could have been obtained illegally in a way that would have violated the confidentiality of the juvenile court records means that Harvard has to act as if it obtained the information illegally and therefore not use it. It's sort of like if you have an exclusionary rule for evidence. You can't say, go into someone's house and acquire evidence through an illegal search or seizure. But what if you acquire evidence through a legal channel, as Harvard did here when it looked at media reports of the proceedings against Ms. Grant in the South Carolina court? Simply because Harvard could have acquired the information in an illegal manner does not mean that it has to now act as if it acquired it in an illegal manner and not utilize it when evaluating her record. I think that is really problematic. Now, I recognize, and I'm sure Derek would point this out if I didn't acknowledge it now, so I'll acknowledge it now. I recognize that the sheriff of Lexington County broke with protocol and allowed media coverage of this trial. But we have to understand that the sheriff was within his authority when he made this decision. He was within the bounds of the law. Now, if we want to strengthen the confidentiality protections on juvenile court proceedings and not allow the media in and not allow the sheriff at his discretion to make decisions like this, fine. But I really believe that is another debate, that is another issue. Harvard cannot ignore this kind of event once it comes to light. And in closing, I just want to say that Harvard has the right to expect from its applicants a certain honesty that goes beyond simple legal obligation. And when it later learns, under mysterious and unfortunate but nevertheless legal circumstances, that an applicant majorly misrepresented herself in the admissions process through acts of both omission and commission, then I would say that Harvard is not only allowed to, but that Harvard ought to reject that applicant.
Thanks, Dave. Scott?
Before I make my case, I have my own set of disclaimers. Ms. Grant has made it known, and it ought to be self-evident, that the publicity surrounding her circumstances hasn't helped. Further publicity is unlikely to aid her, and events like this debate probably serve only as a further invasion of her privacy. I can only argue, as the others do, for what ought to have been done, for it cannot be made right. And I also probably ought to mention that I do not here represent Perspective Magazine. Harvard is very good at making mistakes. Cotton Mather, radioactive breakfast cereal, Van Serg come to mind. Now, so the university's blunders in the Gina Grant case are in keeping with tradition, but another tradition ought to prevail. As the New York Times editorial put it, Harvard has an obligation to behave in an educated way. In the matter of Miss Grant, it has not. Now, Derek has addressed some reasons why Harvard's expectations of disclosure violate the spirit and perhaps the letter of the law. I would like to address some more particular claims that I've heard made around campus in the couple of weeks since this story broke. Now, the distinction that Derek and Dave both drew between legal and moral freedom has often been missed in campus and national debates about the case. I do not question, nor has anyone else, that Harvard was within its legal rights when it reversed its admission decision, although it would also have been within its legal rights, I suspect, to have reversed my admission decision if it knew I had pirated Microsoft Word or illegally dubbed a copy of Ernest Goes to Camp. What I claim is that it acted immorally. Whether you believe the juvenile justice system ought to give its defendants a fresh start, that is how the system is currently configured. If Harvard feels the system is wrong, it ought to be lobbying to change it, not playing vigilante. Rather, its stance has been simple elitism, failing to pay attention to circumstances and instead setting an impossibly convoluted criterion. Dave just seemed right now to want to paraphrase Richard Nixon, who says, when the president does it, it's not illegal. When Harvard does it, it's not illegal. Harvard's moral rights may not be coextensive with its legal rights, but if anything, they are a subset, not a superset thereof. Now, some have noted that there are other applicants ready to take her place. Well, that's true of all of us. I hope the next time I get a B-, they don't try to kick me out in place of a more worthy applicant. Arguing whether or not the killing was justified by abuse is intrusive and fruitless. This was not the grounds for the committee's decision. But many have continued to argue that the killing was unjustified and that the admission reversal reflected that position. These people claim that, were they in Grant's position, they would not have committed manslaughter. But empathy is not a legitimate means of approaching the question. As for recidivism, in the intervening time, Grant has not shown violent tendencies and has instead been an ideal student. As Leon Rosenberg, a Johns Hopkins University's clinical psychologist, has noted, in cases like this, present behavior is the best indicator of future behavior. Harvard's decision effectively placed Grant in legal, but still wrong, double jeopardy. So Grant served her time, made a new reputation, and was admitted on the basis of that reputation. I think once we see what Harvard could have done differently, we can see more clearly why Harvard should have acted differently. Now, the clippings they received are, in a sense, hearsay, legally admissible, but still hearsay. We ought not to believe everything that we read. So it seems obvious that Harvard ought to have spoken with Grant, ought to have re-interviewed her once this information came to light. Officials could have verified that she did not intend to cover up her past in the interview. Now, it has come to light since the first news that she told the interviewer that her mother died in an accident, that she probably only said accident, that car accident was either inferred from another interview that the same alumnus made, or, as the psychologist will tell us, just a common inference. When you hear accident, you think car accident. And in a sense, saying that it was an accident seems little different from the answer Grant gave the Globe. Blamelessly, I think we all think, that it was too painful to talk about. It was a way of avoiding the question, which was within the legal mandate of the juvenile justice system. They could have deferred her a year to let things settle down. They could have given her a single to assuage security concerns. Instead, they did not give her a chance, preferring a knee-jerk to the sort of exploration and discovery which they purport to advocate for their students.
Thanks. Our final panelist will be Steve.
Thanks. I'd like to preface my remarks by welcoming Derek to the debate and questioning the absence of our student body president, Josh Liston. Josh has claimed at various times to represent either the student body or merely his own personal views, or at this point, Gina Grant. He says he's absent here tonight because Gina didn't want him to pursue her case any further. Well, his actions to me seem a bit hypocritical. As a student body president, I don't think he should be representing Gina Grant. I think he should be doing his best to serve the student body. In the last week, he has made every effort to seek as much publicity as possible in the local and national press, including writing up his own press releases, which he then sent out. He's the contact person on them. He quotes himself in the third person. And then today, he's remarkably absent. He claims because Gina didn't want him to be here. I think it's curious that his absence comes right after the Perspective released its, the Independent released its poll indicating that 54% of the student body didn't support the position Josh claimed that they supported. In reaction to an attempt to censure him at last Sunday's student council meeting for pretending to represent the views of the student body when in fact he didn't, and in reaction to recent reports in the Crimson that show that Gina Grant in fact didn't commit an act of omission by failing to report that she committed murder, but in fact committed an act of commission by claiming that her mother died in a car accident. And just briefly, I want to note, Scott, that I don't know where you get your bizarre theory of accident equaling car accident in somebody's mind. It seems that you're pulling facts there that I haven't read about in any news articles, and I'd appreciate it if you could point out which articles you're referring to. There. Okay, I'm sorry. I just like to ask that the student body, the student council, actually hold Josh accountable for his actions, and that the censure motion, which failed at last Sunday's meeting on a technicality, be reintroduced at this Sunday's meeting, and that we in fact ask our student leaders to represent the students they claim to represent.
That's your 3 minutes.
That said, I'd like to take the issue one step further than any of my three colleagues up here have taken it. They've all discussed the issue of lying, whether in legal terms or in moral terms. I think that's a valid issue, and I think that it's what makes the issue of Gina Grant's admission to Harvard so clear-cut. Clearly, this woman committed murder and then lied about it when when asked about how her parents had, or how her mother had died, and it's obvious that as a result, she does not deserve admission to Harvard. Let's assume that Gina hadn't lied. Let's assume that she indicated some remorse, which to date we have not seen. Let's assume that on her application and in her interview she told the truth. Yes, I came from an emotionally abusive, alcoholic family. I led a very troubled life, but I overcame that. And at one point, I had enormous difficulty, and I actually, in an altercation with my mother, I killed her. I served my time, and I feel I've learned from that. And I ask you to admit me to Harvard based on what I've learned and based on my other credentials. Let's say she told the truth. In that case, the issue becomes a great deal more complicated. In that case, Harvard has a responsibility, or any private college looking at Gina's record, has a responsibility to examine not just her application for admission, but the circumstances of the crime that she committed. And even in that case, Gina Grant falls short of the standards of admission for Harvard College. I can readily see circumstances in which somebody claiming emotional abuse leading to the act of murder should be admitted to Harvard College because they've rehabilitated themselves, because they feel remorse, and because they've gone on to lead productive lives. Gina Grant does not fulfill these criteria. The act of murder that she committed was particularly brutal. If you read the autopsy report, as I have, she struck her mother. She left the room where her mother was, virtually defenseless because she had a blood alcohol level of 3 times the normal level, left the room, procured a weapon, returned to the room, and then struck her 13 times in the skull. Now, I'd ask you in your minds slowly to count to 13. That takes an awfully long time. After the first couple of blows, she's almost certainly unconscious. After the next couple of blows, she's almost certainly dead. By the time Gina was done with her mother's face was not recognizable at autopsy. Subsequently, she called her boyfriend, who himself had a juvenile record, asked him to come over, and they then inserted a knife, mutilating the body into her mother's neck, practically severing the spinal cord. And then when the police came over, she lied about it, coming up with various theories. Well, we had intruders in the house. Well, she fell down the steps, and, well, she tried to kill herself. This in the context of a young woman who the week earlier had staged her own kidnapping to cover up the fact that she'd spent the night out with her boyfriend. This in the context of a young woman who had argued with her mother that same day of the murder about that boyfriend spending the night. So I'd ask that Harvard, in that circumstance, consider all these circumstances of the murder and the particular brutality of it, and then the continued lying about it in years afterward leading up to her admission to Harvard College, and the remorselessness. And on that note, I'd like to just quote Gina, the article that was from the Boston Globe magazine profiling her as an accomplished orphan. She said to the Boston Globe magazine, "Life doesn't stop when your parents die. What I do is figure out what I need, then I figure out what I have to do to go get it." She's proven that she believes both those statements. She's proven that life certainly doesn't stop when your parents die, except for your parents, of course. And she's proven that whatever she needs to do to get into Harvard, she's going to do it, whether that means lying about her past or not.
Thank you. Now we're going to have a time for our panelists to engage in some debate among themselves, and we'll sort of let them question each other, beginning with Derek and going back down the order of panelists. So, yeah.
I guess the first question that comes to mind for either Steve or Dave is whether in fact they would favor, as I think they would have to if their position is going to be consistent, a complete re-adjudication of the Gina Grant case in South Carolina. Because if you deny her the rights of non-disclosure, as were granted by that judgment, and you grant to Harvard the information that was given to her, you have essentially undermined the judgment of the state of South Carolina. and I'm wondering whether you've confused Harvard for the South Carolina Circuit Court of Appeals, or whether you simply don't realize that Harvard is in no position to go about re-adjudicating the case at hand.
Do you want to, I can take that.
Sure, go ahead.
Split it up amongst yourselves.
Okay, well, I'll make my response brief, so maybe Steve can get a word afterwards. The first thing I want to point out, and as I pointed out in my opening remarks, Derek, if you want to make the juvenile confidentiality law stronger, fine. But under the law, under the black letter law of South Carolina, the sheriff of Lexington County was fully empowered to make the decision he did in allowing the media into that courtroom. So if you want to be disingenuous about your denial of the importance of legal questions, if you want to jump into the realm of the law, the black letter law is on our side because the sheriff did nothing wrong in allowing the media in, and Harvard did nothing wrong in looking at media reports. The second thing I want to respond to under this point is, well, you're saying, well, the decision of the court means that juvenile offenders should get second chances. Yes. But Harvard, as a private institution, should be able to decide whether it will participate or not in her rehabilitation, in her reintegration into society, based on full information. She should get a second chance, but Harvard should have the facts before itself when it makes a decision as to whether it personally, or as an institution rather, wants to be a part of that.
Yeah, I just say reintegration into society, Derek, does not equate with admission to Harvard University. Harvard's a private institution and has the right to admit those members of society which it deems worthy of the privilege of admission. Whether that's considered elite or not is another issue. But certainly Harvard is not bound by the court's decision. I'd also add that this sort of blind faith that the judicial system judge this case correctly seems to me absurd. We all know that the judicial system makes mistakes. O.J. Simpson, I think, is going to be walking proof of that. And in fact, the judge here was the lone individual who acted against the recommendations of the Department of Youth Services in the state of South Carolina, which recommended that Gina Grant be incarcerated until the age of 21, another 2 years. He acted in defiance of that ruling and suggested that she have a second chance. So this was one lone circuit court judge in South Carolina, and certainly he's a fallible individual.
Thanks. Dave?
Okay. I want to ask a question. I'd like to turn back to Derek and ask him a question. You, as a commentator on the Gina Grant case, you've left quite an interesting paper trail, and as someone who's involved in the Crimson, I was reviewing your earlier remarks, and you said to the Crimson in an April 9 interview that, quote, "The fact that Harvard would probably not have considered the rest of Gina's application if they saw that she had killed her mother is a justification for the fact that she didn't put it on her application." Now, this is actually a debatable claim, but what I would actually like to observe is, if I thought Harvard wouldn't consider the rest of my application if they saw, oh, I don't know, my transcript or my SAT scores, would that be an adequate justification for my withholding this piece of information? In other words, the fact that it was going to be detrimental to her case, while a tremendous part of her life and her record, does that mean that she doesn't have to state it simply because they wouldn't look at the rest of her application? Shouldn't she face the consequences?
Well, I probably should have added to that this was an additional justification for her misrepresentation. I think the best justification for her misrepresentation is that Harvard ought to subsume itself under what I would consider, and I think what many people would consider, a just juvenile system which has created non-disclosure laws. But second of all, the case at hand here the fact at hand here is not something as simple as a transcript. It is what, in legal terms, would be termed prejudicial. In other words, the single act prejudices the entire rest of her moral character. And on that basis, I don't think that if that fact is disclosed, that the rest of her application would have gotten a fair reading.
Okay, thanks. Scott, do you have a question?
Before I give a question, I'd just like to give a citation that Saturday's Boston Globe cited a member of the admission committee responding to a claim by Gina Grant's uncle that that Gina gave the standard response, quote, the way she responded, the same every time. Her mother died in an accident and that she does not care to talk about it. An admissions official said, quote, if someone comes to you and says a person died in an accident, the first thing you think of is a car accident because it's the most common. Gina Grant could have said accident, and the interviewer may have interpreted it as a car accident. Since the interviewer hasn't come forward and people claim that that is in fact what she said, I think there's a reasonable fact established there. But more, I would just like to ask, actually either of the members to Michelle's left, what Columbia University, which has not rescinded its acceptance letter, and Boston University, which is clamoring for Ms. Grant to apply to it, know or feel that Harvard does not, and if there is a justification, why Harvard is entitled to take a holier-than-them attitude.
Well, I would quickly say that much like our student body president, the president of Boston University has been known not to shy away from media attention. The second point is that Columbia's acceptance of Gina was mailed out before they knew the facts of this case, and it's not clear, to my knowledge, whether or not they've rescinded that or not. You know, if Boston University and Columbia University and Yale University and Princeton University and every other university in the country decide to admit Gina, I think that's great for her. You know, I don't know how great it is for them, but that's their decision. But Harvard has no such obligation, and in fact, Harvard turns away a lot of people that those universities admit. Maybe it's a mistake on Harvard's part, maybe it's not, but Harvard has certainly the right to do so, and I think most of the time it exhibits pretty good judgment, and I would say that its judgment in this case is excellent.
Okay. Steve, it's your turn to go for it now.
Okay. Inciting people's past quotes against them. Derek, and Scott also, if you'd like to respond to this. Derek, you're quoted in the April 10 Crimson saying something. When this controversy first developed, I joked to a friend of mine that the next thing we knew, we were going to hear somebody saying that we should admit Gina because of the diversity that she would bring to the class. That was on April 9th. Sure enough, on April 10th, I picked up my Crimson, and there was Derek Ho, co-managing editor of The Perspective, quoted as saying, I think certainly Harvard may have the right to rescind their admission to Gina Grant, but I think that if they're serious about recognizing different life stories, admitting people with those different stories, then she's an exemplary story that we don't often see here at Harvard. I don't think they have any obligation to admit her, but if they had a little more courage, they would. I think Harvard has lost the opportunity to admit someone who would have added to the class of 1999, and I think it was our loss. You know, obviously, I agree with you that she would add something that most students don't bring to Harvard, Derek, but I would ask you if you honestly believe tonight that Gina Grant would bring something to Harvard that would improve the diversity of the student population. Just if you could explain your remarks a little bit.
Well, I think that Harvard's decision knowledge of the fact that she killed her mother is clear indication that it was deemed by the Harvard's admission committee that she would have brought something different to Harvard. In fact, she was admitted, they say, because, or based partially on the fact that she was an orphan, that she came from a troubled family, and that she sort of was a self-promoted success story. And I think based on that fact, it is clear that she would have provided something to the university that was different. And my point, as humorous as you make it sound, is that the fact that she killed her mother is not a primary character trait and does not take away from the fact that she would have provided something very interesting and very different to Harvard's campus. I mean, if you look at the panel here, I don't think there are a lot of us that can say that we went through the type of troubling incidences that she did and nevertheless succeeded. I mean, a lot of Harvard is sort of upper middle class, comfortable. Their successes have been padded by the fact that they've had fortunate social circumstances, and I think this is one of few exceptions that Harvard should have taken advantage of.
Okay, thank you. Did you have anything you wanted to say? All right, now we move into the next phase of tonight's program, and that's the time when audience members are welcome to get up and ask questions. We have 2 microphones set up, one in this aisle here and one over there. I just ask that before you state your question, you tell us who you are and any relevant affiliations that you may have. And if you just line up behind the microphones, we'll sort of alternate back and forth, I guess, beginning over here.
Some people may consider this offensive, but I think it's a fair question for the pro-Harvard side of the argument that I follow to ask people whether they'd be willing to have their daughter as a Harvard student room with Gina Grant. My girlfriend is furious at me for making this argument. I'd like to hear from the panel why this argument is unfair or why it is fair. Thank you.
If I could just quickly say, that argument strikes very close to home. I have a younger sister who is going to be in next year's freshman class, and the first thing she did when this story broke in the national press was call me up and say, if Gina comes to Harvard and I come to Harvard and we get assigned to room together, can I transfer? And I think those sentiments are probably shared by a lot of her future classmates. I think it's a great concern, and I agree with you that nobody should be subjected to living with a convicted, essentially a convicted murderer, whether we call it voluntary manslaughter or not, somebody who bashed their mother's skull in 13 times.
I think the contingency of Harvard's finding out of this information makes the argument weak, though not necessarily false. Had Grant changed her name, say, or no one in South Carolina found out that she had applied to Harvard, obviously the information would not have surfaced. The concern never would have been present. But even if we try to get beyond that, I mean, the recidivism claim is just bizarre. Only 8% of all parricides are committed by women or girls. But more relevantly, in cases of parricide, the sociology or the psychology will tell you that children who have no other behavior problems, who kill their parents in abuse situations, never have other behavior problems beyond, anyway, what is normal. And it's, to use Derek's word, prejudicial and just non-germane to try to call this particular incident, which was not a drive-by killing, which was not a random act of violence, but a very particular and, in fact, unrepeatable act of violence, and to continue to hold that against her.
Scott, I'd just like to correct you. The claim that she doesn't exhibit any continuing behavior problems strikes me as a bit bizarre. Gina's now living on her own in a one-bedroom apartment in Cambridge because she couldn't continue to live with her aunt and uncle in Cambridge. She moved out 2 years ago because they couldn't get along. I don't know, that would suggest to me some sort of a behavior problem. She couldn't get along with her parents, she then couldn't get along with her aunt and uncle. Well, either her entire family is at fault, or Gina's at fault.
That would suggest to be an inability to be tolerant of other people's situations and just to presume that others' childhoods were comparable to our own. And they were not necessarily.
We're talking about a dormitory rooming situation.
Did you grow up with your, aunt and uncle? I don't think it's necessarily possible to put oneself in those shoes a priori.
I also think that not only, I agree with Scott that the fear is unjustified, but I also think that fear cannot be a factor in affecting the admissions of anybody. I mean, if you think about it, it is very possible that a large percentage of the student body would fear having a roommate that is HIV positive. And I don't think that fear is at all justified. In the 1940s, 50s, and 60s, a lot of white students may have been very fearful of having a black roommate. I mean, fear simply cannot be an element in the decision process.
Okay. We're going to go to this microphone next.
I wanted to ask everybody involved here, suppose instead of a news, my name is Ron Newman, I have no relevant affiliation since you wanted that to begin with, okay.
Relevant ones that you wanted to share?
Well, I went to school down the road at the other end of Cambridge, but anyway, suppose that instead of, somebody having clipped it out of the newspaper in South Carolina and mailed it to the Harvard Admissions Committee, which it sounds like is what happened here, suppose instead of that, what you had was some member of the Harvard Admissions Committee on his or her own decided to go do a Lexis search or a search of some other database that archives old newspaper and magazine articles and located this piece of information. Would it be right in general for the Admissions Committee of Harvard or any other college to try to obtain information in that manner that wasn't volunteered by the applicant and That's basically it. I'm curious how that would change this if it had been done that way.
Well, I certainly think that it's legitimate for Harvard to go about trying to find additional information. I mean, if not simply by requesting it from the applicant, then by doing it on its own. But the question isn't how the information got to Harvard. It's whether Harvard ought to consider the information. And the main problem that I have with Dave and Steve's argument is that it presumes that Harvard knows better when it comes to juvenile criminal justice. Because if we view the system as just, and the point of the system is to provide a new start for people and to withhold prejudicial information from prospective employers and university administrators, if we view that as just, if Harvard views that as just, then I think it should subsume itself under that law, whether it be an ethical law, a moral law, or a legal law. It doesn't really matter to me. If that is a just law, then Harvard ought to subsume itself under it and not to take into consideration whatever information it finds or gets.
Derek, if a student cheats on a high school exam and is punished by being suspended for a week and then is admitted to Harvard, then applies to Harvard, does Harvard have an obligation to overlook that suspension because the student served his week-long suspension? I'm sorry, does Harvard have responsibility to overlook the cheating because the student served the week-long suspension?
Well, I mean, it depends. It sort of depends. I mean, cheating is, first of all, an academic issue, and which is a little bit more pertinent. But the point here is, if somehow if you viewed it as just that this type of information ought not to be given to employers or university administrators because it is so prejudicial that it will preclude a fair reading of the entire rest of the application, then you should not consider it even if you have it.
It just strikes me that you're saying, one sentence, that you're saying that if it's cheating on an exam and the school releases that information, that's fine. But if it's murder and the state decides to withhold that information, then Harvard has an obligation to overlook it. So whereas cheating on an exam could keep you out of Harvard, killing your parents is big enough that Harvard has an obligation to overlook it.
Well, if you want to take that line of argument, then fine. Then what you would have to do is argue that there should be no non-disclosure laws in the juvenile criminal justice system, because that is the way it is, and I view that system as just. And if you do too, then I don't see how you could not conclude that the things that the criminal justice system intends to withhold ought to be withheld.
Oh, I just wanted to add, back to your original question, Derek definitely steered us away from the topic at hand. I think that while I wouldn't advocate Harvard admissions officers trying to engage in this grand inquisition of every applicant, I think that if such information is obtained by Harvard or does come into, fall into Harvard's mailroom in Byerly Hall, as the case may be, then they are, and it does point to some major act of misrepresentation or dishonesty, I think that they would be justified in using it. In response to Derek's point, I really think that he is overemphasizing the power and the jurisdiction of this South Carolina court in determining the activities of private individuals and institutions. As I stated before, yes, juvenile offenders should get second chances, but Harvard should be able to decide whether it's going to participate in this process. Does this mean that because the judge said that nothing prejudicial about Gina can be released, kids who live down the block have to be bound to be her friend and can't be scared of her because the judge said, nothing prejudicial, don't use this event to judge Gina Grant's character? Clearly, this is ridiculous. They're private institutions, they're private people, and while I concede that the court has wide jurisdictional powers to govern the activities of other institutions within society, I think, Derek, you've taken a reasonable argument and taken it way, way too far.
Well, I'm really not talking about legal jurisdiction, sure. The case of whether South Carolina's legal jurisdiction extends into Massachusetts, or the question of whether Massachusetts law is coextensive with South Carolina's, is going to be a question that will come up in litigation. What I'm talking about is presuming that you view the system as just, then what conclusions follow? And
so answer my point about we have to all be her friend now, because we can't use our knowledge of this murder to taint our judgment. That private institutions and individuals have to be compelled to feel and act towards Gina in a certain way because this one random judge made this random ruling.
No, not compelled, but the point of withholding the information is so that people won't have to be compelled to like or know or not fear Gina Grant.
It does sound as though you said Harvard ought to be able to opt out of the legal system and last I checked, individuals did not have that right. I would think that since the intent of finding the information, witch hunting is different from things falling in your lap, and because a Lexis search would find certain kinds of morally dubious behavior but not others, that you would at least have to solicit a student's or an applicant's permission to conduct such a search. And I don't believe there is.
That's a matter of public record. As
Required.
someone in
I'm
the
sorry, I could not hear you.
Perhaps it wouldn't be legally required, I don't know, but it would seem to me that you would, in good faith, have to ask for a waiver to do background checks, and then you would have to do, I mean, to be fair, an FBI background check on everyone, and that's simply impractical.
So do you need to ask Gina's permission to read the paper when the articles concern her?
No, that's why, but I would say
But a
that there
Lexis
is a
search is
different,
just
there's
a
a
search
different,
through
there's a
newspaper
difference
files.
in intent. If Harvard admissions committee did the Lexis search, or if someone who had it in for her.
But Scott,
did
it's on the
Lexis
public
search.
record. The only things that are contained in LexisNexis searches are things that have been that have appeared in print media or broadcast
The presiding
media.
judge has said time and again that the problem with the case is the First Amendment rights, the freedom of the press and the electronic media has gotten ahead of the closed case statutes, and there just isn't a resolution for that yet. It's not as clear cut as you make it.
It is unfortunate that the sheriff was within his jurisdiction and within his rights and within South Carolina law when he allowed the press into that courtroom. But Harvard acted justly in this instance. If you gentlemen want to start a two-person campaign to make it stricter and to deny the sheriff that prerogative, fine. But let's look at the case at hand.
No, but the justice of the matter is completely independent of whether the sheriff was within or without his jurisdiction when he leaked the information. The only question that is relevant in assessing the justice of this situation is whether we believe that the information surrounding the case in South Carolina ought to have been withheld. And if we believe that that is just, and if we believe that that system is just, then the legal contingencies don't matter, because we're sort of taking a step back. The legal question is irrelevant because we don't know the answers to all the legal
I
complexities.
like how you say, you're very disingenuous about this, Derek. I like how you say that the legal question is irrelevant and then ground your entire case on the legal system, Derek.
Well, no, I'm not grounding her case on the legal system. I am grounding her case on the question of whether the legal system is right. And if we believe that the legal system is right, then certain things follow, and it follows to our side.
Okay, Ben?
Hi. My name is Ben Torrance. I'm a senior at the college. Just to point out, incidentally, according to all the accounts I've read, it was the judge who has the prerogative to let
And
the
in this
media
case, yes, we'll go on.
And in this case, it was the judge. Anyway, my question is directed towards specifically Steve Frank, but also Dave Ladd, if you'd like to attack it. You've talked a lot about remorse and seem to imply you gave 3 criteria for allowing someone in her circumstances to be admitted to Harvard. And the only one she seemed to violate was that she showed, in your account, no remorse. Now, the sort of Calvinist underpinnings of that assumption notwithstanding, what do you base that on? She has not made any public statements. The only people who have publicly said, according to what I've read in the newspapers, who have said that she has not shown remorse has been the prosecution. Of course, it's their job to say that she has shown no remorse. And a second related question. If there's plenty of evidence to show that the killing was justified, despite your putting her on trial here based on an autopsy report, a lot of people have said, including apparently the judge who gave her essentially a slap on the wrist, that the killing was justified. Now, if it was justified, why does remorse matter? If she had killed her mother in true, actual, unquestioned self-defense, would remorse matter? Would that be a criterion?
Okay, question number 1 on the issue of remorse. If I left you with the impression that remorse is the only criteria that Harvard should consider in evaluating the murder, then I apologize for that. It is one important factor. The brutality of the murder, for example, is another.
It seemed of the criteria you gave, that was the only one that she did not satisfy.
Well, no, I think the murder was quite brutal, and if you'd like to look at the autopsy report, I mean, it's pretty gross. The issue of remorse, though, she certainly didn't satisfy, and it wasn't just quotes from the prosecutor I was citing. I was citing Gina Grant, who said in a recent Boston Globe magazine article, "Life doesn't stop when your parents die." I think that indicates a lack of remorse.
Oh, sorry.
And the case of brutality, again, I think 13 blows to the skull is pretty brutal when and then mutilating the body afterwards with a steak knife. On the issue of whether the killing was justified, a lot of people here speak as though they know Gina Grant. She was suffering such abuse. Well, the fact is, if you saw her uncle the other night on TV, he said, yeah, she was under a lot of emotional abuse. I mean, her mother would come home late at night, drunk, loud. Gina couldn't sleep. Well, that doesn't strike me as the type of emotional abuse that warrants murder. Furthermore, nobody is claiming that this abuse extended anywhere beyond emotional abuse to actual physical abuse. Nobody is claiming that Gina was acting in self-defense. If anything, if you read the autopsy report, her mother had multiple lacerations on her left hand consistent with defense wounds. So it was her mother who was trying to defend herself
Her attorney has claimed both those things.
from her
Her
daughter.
attorney has claimed that she is
Well, he
acting
didn't have a
in
chance to
self-defense.
actually because it didn't go to a court where he would have been able to make a self-defense claim. In fact, Gina left the room, procured the weapon, and came back. So I think the self-defense claim, she could have just as easily left the building. And in fact, I think along those lines, she had a lot of other options that a 13 or 14-year-old should know about, such as approaching a relative, approaching a counselor at school, leaving home, but not killing your mother. I think every 13 or 14-year-old knows that killing your mother is not the first option you should try.
And if I could just briefly interject here, in the Boston Sunday Globe magazine, which glows radioactive in her praise, this was before, of course, all the information was released, Gina says, quote, "I think there are always enough people to help with pretty much any problem you might have. So I would ask, why didn't she turn to those, quote, any other people when dealing with an abusive relationship? Clearly, or what she perceived as an abusive relationship. Clearly there were problems here with her family, but there were a variety of ways of solving the problem. And Gina herself acknowledges in this interview that whatever problem you have, turn to someone else before taking, it into your own hands."
There's a lot of people who grow up in abusive and alcoholic households and manage to survive without killing their parents and manage to lead pretty successful lives. And I think those are the people we should be questioning why they aren't admitted to Harvard, and not Gina Grant, who took the most brutal and vicious option that was available to her.
I find this projection of 20-year-old men in ties to 14-year-old girls in South Carolina bizarre and grotesque, and I find the questioning that emotional abuse could not a priori be as severe as physical abuse also bizarre and in contradiction to any facts and studies on that sort of thing. There is more information that I just as soon not present about the details of the emotional abuse. It was more than what was described. And I think one just has a general human compulsion to take people at their word when they claim abuse, unless there is some information to the contrary. And the presumption that any 13 or 14-year-old knows what sources of authority can be gone to is also, to me, bizarre.
It's also interesting that Steve criticizes us for saying that we know Gina Grant, and here he's presuming that he knows that Gina Grant is wasn't so abused that she could not have refrained from killing her mother, and two, that she is not remorseful. If anyone's presuming that they know Gina Grant based on Boston Globe reports and New York Times reports and reports in the Crimson, as wonderful as the Crimson is, I think that's really a bit ludicrous. And I think that goes to the question of how Harvard handled this. They never really asked the question of what Gina Grant's current mental and moral state was. They cut off, they made the decision before this question was even answered. And I think that, in fact, is the most unfair part of this. She never got a chance to plead her case to show that she is remorseful and to show that she deserved admission to Harvard.
I just want to add one little note here. I just want to first of all apologize. I'm sorry, Steve and I have to go on these Boston Globe and New York Times reports because, unlike Scott, we don't have that a red line hotline to the Grant household where we, hear the juicy details of all
Boston
the
Herald story.
Oh, okay, sorry.
And neither do no, but Dave, neither do we have the red. Information on the Grant household, and neither did Harvard, and that's my point.
But we do have information on the fact that she was not physically abused. We have information on the fact that she brutally slaughtered her mother.
Are you a psychiatrist?
And that's
Are
no,
you
I'm not a
But not
psychiatrist.
even the
what's
defense.
going
And
on here?
I shouldn't need to be or Harvard's admissions committee shouldn't need to consist of psychiatrists and psychologists to come up with admissions decisions on students.
Do you think there can be justifiable homicide, though?
Oh, I certainly think there can be justifiable homicide,
the
and
fact
that's why I
that- so you're
suggested
using the
earlier.
fact-
Because
That's
justifiable
why-
homicide
using-
exists
that's
doesn't
why-
mean it occurred in this.
But you're using the fact that it was a brutal killing to say that it wasn't justifiable, which
Well,
is completely
for example,
untenable.
I'll give you an example of a justifiable homicide. If Gina Grant had, in the heat of anger, picked up a gun and fired a single clean shot, that's different than beating somebody 13 times. Just count to
Gun control
13.
laws are not at issue.
Just count to 13 in your head, and I think you can't help but be disgusted by what she did. The one other point I wanted to make is, Scott, I appreciate you bringing up the issue of gender, and I would just ask you, if Gina Grant were not a woman but were a man, do you think you'd feel as much sympathy for her as you
It's
have
not
into
an
tonight?
issue of sympathy. I don't think sympathy enters into it. I was trying to leave that out until the gory details became part of your emotional appeal. I mean, John Hinckley Jr. fired 6 shots at Reagan in under 2 seconds. I don't think that your statistics about the speed with which the candelabra was brought down mean anything. We're not criminologists. I don't think any of that has any bearing on anything at all, except that it has a visceral emotional appeal.
And your characterization of what is and is not justifiable homicide, I mean, Michelle, you left the MD and the JD off the end of his name card. God.
I didn't make the name cards. Yes.
May I ask a question too? I'm from Belgium. I don't know much about the case. I'm just a fellow here at the CFIA. But I just wanted to tell the panel how brilliant they are, all of them. And after having said that, I'd like to ask them a question coming back to the case as the case should be treated. Admission or not admission. Is it true what we are told in European countries that not only the credits you get and the A grades or whatever is taken into consideration when you are admitted here, but also whether you're good at sports or whether you're good in music? And in this case, whether you are an orphan or not. Well, if the fact that she being an orphan played a positive part in her admission, I think the fact that she became an orphan by her own killing should be taken into account, and that this factor, having been a positive one, should then become a negative, and it would be enough a reason to not admit her. May I have your opinion on that?
I think you're absolutely right, and it's in accordance with the traditional definition of chutzpah, which is the child who kills both his parents and then pleads for the mercy of the court because he's an orphan. I think Gina Grant fulfills those criteria.
I also want to say I agree with your point very strongly. In the April 13th issue of the Crimson, we reported that one of the things that she had going for her was the fact that she was an orphan. And if she was a self-proclaimed, I think Derek used the word self-proclaimed, I think it's a very good word in Gina Grant's case. If she was a self-proclaimed, or rather self-created, self-made, or self-formed orphan, I think that ought to count against her, especially if this was one of the things which Harvard used to bolster her case. We have many people who are A students, captain of tennis teams, biology tutor, etc. But this angle, it's regrettable that the college admissions process reduces personal tragedies like being an orphan to angles, but unfortunately, it does look at those things, and if it does look at them and count them, it should also look at the ways in which those situations arose.
Well, I think that the fact that she created her orphanhood, if that's a word, makes her case no less difficult and her case no less tragic. And I mean that's a judgment call in the case of Harvard. But the fact is that Harvard is not claiming that she was denied admission because the facts of the case somehow changed their judgment of her as a person. They are denying her admission simply on the basis of misrepresentation, and I think that is problematic.
Never mind.
I also just generally, find the argument from chutzpah a little bit unconvincing. Not having served on an admissions panel, perhaps unlike Mr. Latt, I don't know, but it also seems that certain schools tend to receive certain standard numbers of admission. I don't know any of the people involved, but it sounds as though she was one of the top students at her school, and I believe 10 students from her school received admission this year. So I think chalking her admission up to standard applicant grades plus orphanhood is an unnecessary and perhaps wrong reduction.
Hi, my name is Jessica, and I'm a student at at Harvard College, and I also graduated from Cambridge and Latin, and as a self-created orphan, I guess you could say, somebody who chose not to live at home. I felt very attached to this case, and I've had a more personal perspective, I think. And I was just kind of thinking, if somebody chooses, I guess I'm just wondering that what moral character really means. Is it who we are today or who we have been in the past? I know that for myself, having come from, I guess you could say, a somewhat similar background, I was not the ideal student. I was not the ideal child. And I choose not to get into any of the kinds of things that I may or may not want other people to know. Harvard specifically called me back in to ask me certain questions. There were some that I answered, some that I, like Gina Grant, avoided. And I just think it's interesting that my moral character, who I was at that time, was considered to be much more important than any of the things that may have been confusing about my past. And I just wonder how you can justify moral character, especially at such a young age. I think it more represents who we are today. I guess it's more a comment than a question, and I don't know if any of you have a response.
Yeah, I think that you raise a very interesting point. What I would observe, though, is I would make two observations. That first of all, it's not as we can't draw a clean and easy dichotomy between who we are today and who we are in the past. I'm no physics major, but I think time is a continuum or something, and so you can't have this very neat, discrete point where you say I was this person then and this person now. The second thing I would say is, if indeed she did she misrepresented the facts. And so even if you put aside judgment of the murder, which I guess in the way I presented the case is more easy to do than with Steve, although I think that I think he'll address this too. If you look at the misrepresentation, that brings into question her moral character, not in the past, 4 years ago or so when she committed this action, but in the present.
Don't you think Harvard should have asked, though? They certainly have the opportunity, and they took that opportunity with me when there was some question, a small question.
Yes.
And it's simple enough for them to do that, especially considering that, she's right next door.
I'm very glad you asked that question, actually, because Scott made a point which I wanted to refute on that point. The New York Times also made this argument about due process, saying that they ought to have called her in and asked her again about these matters before summarily deciding to take this action. But let me give you an example, and let me see, and I think that this example would be justified. If someone had claimed that they were president of the student body, or if someone had falsified SAT scores, or if someone had falsely claimed that they were president of the student body, and then it was later discovered through a conversation through a guidance counselor perhaps, that this person was not in fact the president of the student body. Harvard has, I know of cases, and other institutions have as well. They have unilaterally acted when faced with evidence of misrepresentation, have taken action before even bringing that applicant in. And I think that this is a heck of a lot bigger than saying that you were president of the student body when you weren't. This is big.
Can I
There's certain
respond
information
specifically?
they request there.
Steve and then Scott.
I'd like to respond specifically to Dave. First of all, misrepresentation in this case is not necessarily a sign of moral character. It has been asserted by Margaret Burnham, her attorney, that Gina Grant did not fill the application in on her own, but rather acted on the advice of counsel. And if counsel had advised her that this was not only legal but also moral in their judgment under the jurisdiction of South Carolina, then this may not have been a misrepresentation which reflects on moral character.
So I have a question. Lawyers can pass on legal aspects. Now we're getting our morality from the lawyers? Lord, help us.
Well,
The lawyer can tell her
If you
this is
believe
legal
that-
or not. They can tell her whether it's ethical.
Well-
She loses all moral agency. She just says, oh, well, you told me
no,
that. So.
but if she believed that the non-disclosure rules under which she was a subject were just, and if she believed that she had the right, morally and legally, under these rules, to keep away this information from Harvard, then this is not necessarily misrepresentation, which is the same as misrepresentation in the case of simply writing something down that is not true. Also, and to sort of deconstruct the analogy that you made to this person that simply puts down president of some organization, which is completely false. There is very little chance that there are mitigating circumstances in that instant. I mean, it's just a blatant lie. And in this case, I think you have to regard the particularity of the circumstances in which Gina Grant was involved.
Steve, did you have?
Yeah, just quickly. Well, it wasn't an issue of just checking off the box, because she did claim in the interview that her mother died in an accident. Whether it was a
Well,
car
that's still
accident or
disputed.
another kind of an accident, we don't know. But an accident is certainly not how she died. It was voluntary manslaughter. And just in response to your point, Jessica, I do believe that time can be a mitigating factor in these types of circumstances, and I would say that time is not working in Gina Grant's favor. Her murder was committed only, the murder that she committed was committed only 4.5 years ago. That's not a long time. And again, you know, if the Department of Youth Services, which did administer psychological counseling and tested Gina, had its way, she would still be in jail for another 2 years.
Scott, did you?
Yeah, just something. These aren't any 4.5 years. These are the most, or among the most formative 4.5 years. I don't know what the physicists say either, but I know philosophers do speak of past selves and future selves, and I think people are defined, at least to some degree, by their context, and obviously the context in which Ms. Grant has lived has changed considerably. You spoke, Dave spoke of these issues. There are not, to refocus, these issues. There is an issue of misrepresentation. That is all the admissions committee has said is at issue, and it is all that ought to be at issue.
Yes? Actually, I think I'm sorry, I screwed up. We're supposed to go over here.
My name is Alex. I don't have any affiliations here. But the question I have is, if Gina Grant was admitted and they found out all this information when she was a sophomore or third-year student, what would happen? Would you guys will have the same position?
That's a great, great question. And I think we would follow the precedent, or I would hope we would follow the precedent of Yale University, which a week or two ago expelled a student who was a month shy of graduation because he falsified all of his records for admission and for financial aid. So, you know, he had fulfilled 2 years. He had transferred, and he had fulfilled his junior year and most of his senior year and was about to graduate. And they kicked him out and are now, I believe, suing him for fraud. So I would hope we would follow their example.
I still think that there is a complete disanalogy between someone who simply lies for the sake of lying and someone who has lied to protect what she believes are her rights under a just system. And I just don't see how you can draw an analogy between those two. You simply haven't taken into account any of the particular circumstances which surround this case. The fact that she was arguably acting under non-disclosure laws doesn't mean anything. I mean, is it completely analogous to the precedent that you're trying to draw? It doesn't make any sense to me.
Why do you keep defending Gina's rights? Why don't you talk about her mother's rights? Nobody's mentioned her mother here tonight.
That case has already been adjudicated. Harvard is not a court of law. Harvard is not considering an appeal of the case. I don't understand why you want to revisit the entire crime and the entire adjudication of the matter, because Harvard is not in a place, and nor should it be in a place, to do so.
So you would suggest that the courts in this country never make mistakes, and we should be bound as private institutions by what the courts do, whether they're right or wrong?
No, I am not saying that they are bound to do it, but I think in this case, I think the non-disclosure laws are correct, and I think that if someone had wanted to appeal it in South Carolina, they could have, but Harvard is not here.
Prosecution can't appeal.
Well, whatever, fine, they couldn't appeal. It doesn't really matter. I mean, legal justice has been served, and even if you don't think it's been served, Harvard is not here to serve it or serve it again.
Okay, yes? I think we're going to take 2 more questions, and then...
I'd like to ask the members of the panel to briefly comment on what the implications of Gina Grant's acceptance might have, or her refusal at Harvard and her acceptance at Brown and Columbia might have on the image society places on Harvard College, and also to speculate a bit on how the role of Harvard College, as I have heard it referred to in my hometown as a cradle of leadership, would have been or could have been a deciding factor in the admissions decision to, frankly, not wait to hear Gina Grant's response and quickly deny her acceptance.
Well, I would just say briefly that Harvard, as Dave said, has no obligation to hear her side of the story once she's given her side of the story one time. And he provided the excellent example of, somebody who cheats in school or who lies about their academic record not being obligated to have a second chance. The other point is, while I don't think Harvard really needs to worry too much about its image as a result of this case, this year applications were around 18,000, more than they've ever been. I think, and you might disagree with me on this, but I think that this case can only help Harvard's image as a selective institution. And I think probably you'll see applications go up even further. And certainly you'll see people from all sorts of penitentiaries applying and acknowledging their records, I'm sure.
Oh, I'd like to just add to that. Well, the first thing I would say is I don't think it would negatively, I don't really think that the effect would be negative. I think that here, in this hotbed of liberalism, we're tempted to think, oh, we're tempted to identify with her, she's the victim, give her a second chance. When I talked to some relatives and friends back home, just over the holiday weekend a little while ago, they were horrified about the case of Gina Grant, and they were very supportive of Harvard in doing this. So I think that if you base it on, I don't know, the residents, of the community around Harvard, of course they're going to say Harvard is elitist and evil for rejecting Gina Grant. But if you go to the heartland, or, if you go outside of this liberal peninsula that we're on, you're going to find some pretty solid support for Harvard. The other thing that I would say, though, is I'm not going to, make this definitive or anything, or say that I'm a perfect seer. Scott has sort of been pestering us the entire evening with these epistemological cheap shots like, you're not a lawyer, you're not Gina Grant, you're not her friend, you're not a psychologist. But I don't understand why the epistemological cheap shots don't apply equally to their side. They're not legal experts either, so who are they to expound on the justice system? They're not psychologists, so who are they to expound on whether or not she was abused? I don't understand why this epistemological weakness or this absence of full information only cuts against us.
Could I have just a second?
Sure.
To respond to your question, and you seem not to want to hear my answer since you're walking away, but I mean, I agree with Dave in essence. I was on a radio talk show down in New Orleans, and they all agreed with Harvard's decision. They think that Harvard University is a bunch of kooks and liberals, and they don't care anyway. But and I think that that's what Harvard did. They took the easy way out. And to respond to Dave's question about epistemology, the point is that on our side, we haven't been arguing about the legal specifics. We've been arguing about what is right, and we've been arguing about what is just.
Then you should be a philosopher. You should have a PhD in philosophy. That's even more years than a JD.
Well, I would say that you can be an amateur philosopher. It's very difficult to be an amateur legal expert.
We're not, okay.
This will be the final question.
Okay, my name is Fred. I'm with the Grad School of Ed, Harvard Grad School of Ed, and no, I'm not a legal expert, so I won't even try. However, there's a few questions. One in particular is this. You mentioned about the selectivity of the institution, that somehow the application pool will increase next year and will be shown to be more selective in the type of students that we bring into the institution. However, I don't think that we'd like to be noted for that near as much as we like to be noted for being a place where people think things through, to where we look at a situation and we look at the environment and we look at the individual and we look at all the other things. We look at the grades, the SAT scores, the extracurricular activities, the alumni interview, which is interesting, Mr. Frank, OJT expert here. It's interesting that you mentioned that she never mentioned it to the alumni interviewer. However, if you remember back when you had your interview with the person who interviewed you, wherever you were, that interview, in fact, is not, a lot of weight is not put on that interview, because these people don't really represent the admissions committee. They are simply people who are located in various regions of the country who graduated from Harvard, and they avail themselves and take the time to interview the applicants. So I think we can't stand on that as, we can't put any strength on that as being important. The fact remains, what we should do, though, is look at the fact that Harvard accepted her on the things that they accepted her on. They accepted her on the character that she's shown, irrespective of the fact that there might have been other things. I think of how many students that we have here at this institution on the graduate and undergraduate level who might have been juvenile delinquents, involved in gangs, cheated in school. I mean, all kinds of things. Who knows the things that people can bring up about your past? And I think that we have to be careful that we don't put ourselves up as some sort of a second court, that we are now a court system where we decide to retry her. Because, in fact, the court that did try her made a certain decision. I know you mentioned that there were other things that they wanted to do down there in South Carolina. However, they couldn't do it. The court in the end decided that the case was closed. And I think that we have to come to that same decision. And I think it would have been best had they brought her in, sat her down, had a conversation with her, and discussed these things with her before just blatantly coming out and saying, hey, you're out, that's it, we've gotten this information on you. And I say that because the court system never relies on those types of information. It doesn't. A person just can't write something on you and they say, oh, here's some new information, let's make this a part of the case. And we do that because we know it's easy for things like that to occur. So we should not set ourselves up here as any sort of a court system, but simply look at the case the way it is. The fact is, she was accepted on her merits. Her merits at the time, not what happened 4 years ago. I mean, we all change. You can look back at how you were, what kind of person you were 4 years ago. And I'm speaking to everyone here. Look at the kind of people we were 4 years ago. And who knows what you're going to be 10 years from now. I mean, we all go through this process. And I think it would have been the best interest of Harvard to put itself in a light in society of one where we look at it and say, we take a lot more things into consideration. We consider the whole person, we consider the environment, and we consider circumstances.
I'd like to, can I address that? I think your point is absolutely on the mark. I think it's excellent. We take a look at the whole person, we evaluate the whole applicant. And what is essential, what is foundational, what is essential to the system upon which we look at the whole person? That people tell the truth, that people engage in accurate self-representation. And when Harvard rejected Gina Grant for misrepresentation, they were not only rejecting her, but they were upholding the integrity of the system that, as you described, sir, looks at the whole applicant, looks at the whole truth, and that is what they were doing.
Just go ahead. Quickly, I agree with you. First of all, I agree with everything Dave just said. I also agree with you on your point that the interview doesn't carry a whole lot of weight. And it's really an opportunity for Harvard to make itself look good, to say we do interview every applicant. But at the same time, the interview is an opportunity if the applicant chooses to make it one, and most applicants don't know that the interview doesn't carry a lot of weight. It's an opportunity for the applicant to say, there's something I didn't say on my application that I'd like to tell you here, and it will be heard by the admissions office because the interviewers do file detailed reports with the admissions office. So that's the one point, and I would just heartily echo Dave's point that Harvard is making an attempt here to judge her on her moral character, and it's a more complete moral character than she presented to the Harvard admissions office. And I think, on the issue of whether Harvard was hasty or not hasty, we can argue both ways. Maybe Harvard, if it had known that this was going to be such a public relations issue, should have called her in, but they certainly had no obligation to do so, and it would only have been from the standpoint of public relations, and I really don't think Harvard has an obligation to judge candidates on whether or not it's going to be good press.
Although I don't think you'll deny the fact that they in fact probably did know it wasn't going to be very public and took advantage of the situation. I mean, we can't be so innocent as to assume that they said, well, we can just rescind the admission and nothing will be said about it. I mean, I really think that, and I've worked in the admissions office here and I've worked in other universities, and let me tell you, when you decide to do things like what we did, people sit down for days and nights and evenings and make certain decisions before they go out. You're not just one, a person didn't pick up the phone. I'm certain someone didn't pick up the phone and say, look, go and call up the Wall Street Journal and tell them we're going to rescind this application. I'm pretty certain that it wasn't done that leisurely at all. Just something for you to consider.
Scott, did you have something?
Well, I'm just, to echo, wearying of Dave's metaphysical cheap shots, I think, and I also endorse your idea of what thinking things through would entail and gathering further evidence and not relying on the first thing you hear. Obviously, what's at issue here is what was truth. What was a true thing to say? Boston University does not have a question about an applicant's criminal or disciplinary past because it's so hard to verify. That's the reason that Silber says they don't have that kind of question. And so the issue, just to bring it back again to what even the admissions committee says was the determinant, that she did not, whether or not she misrepresented the truth, is what is at issue, is what has not been adequately investigated, and what needed further investigation. It was not an issue of moral character as defined by the Act. It was an issue of moral character as defined by the revelation, and that was obviously not adequately investigated.
Do you have something you want
Well,
to say?
and finally, that it's interesting that Dave says, oh, we look at the entire moral character, and then we say, oh, she misrepresented herself on the application, and we isolate this aspect, we universalize it and say, this is what she is. She is a liar, or as Steve would have it, she is a mother killer. If she had a second mother, she'd do it again. And I think that that's just simply, one, is simply wrong. I mean, in light of all the character witnesses that have come forward and expressed that this is not her character, and two, is simply a determination that Harvard never made. And I don't think that Steve or Dave can really adequately say whether this is or isn't the determinant character of a determinant trait in her character.
And I don't think you can either.
Yeah, how can you second guess a huge admissions committee? You're the people with the epistemological dilemma.
No. I mean, we are.
I don't even know what an epistemological dilemma is.
I think on that note, we're going to end. The reason that I chose the panelists was because they were students, not lawyers or anything else. And because, in the words of one questioner, they're brilliant. Or so she thought, or at least I thought, and still do after this panel. I'd like to thank all the panelists and the audience for attending. It was a wonderful evening.